C Judgment 112 宪判 6, 2023. Case on the Special Judicial Remedy Procedure for cases concluded by military courts. Hand notes. The TCC upheld the constitutionality of Article 181, Paragraph 5 of the Military Trial Act 1999 version, which limits ground of appeal to the civilian court for military personnel to the contravention of laws. That is, only the ground of the contravention of the laws can file an appeal to the civilian court for military trial. To prevent miscarriage of justice, the TCC established a new ground for retrial. So another new ground of retrial has been established by TCC. Although TCC upheld the constitutionality of Article 181, Paragraph 5 of the Military Trial Act of 1999 version, where the military court convicts the accused soldier based on primarily the same evidence which the civilian court has acquitted the soldier's civilian accomplice with. The accused soldier may file motion for retrial on the basis that the two separate trials contradict with each other on their finding of facts. So the appeal show the limited ground of appeal for the ground of contravention of laws is constitutional, but there is a new ground for retrial because retrial is different from appeal. And if there is a condition that the civilian court has acquitted the soldier's civilian accomplice, then the accused soldier may file motion for retrial on the basis that two separate trials, that is, between military trial and civilian trial, contradict with each other on their finding of facts. Background note: I will skip the facts here. Before this judgment, Taiwan changed the jurisdiction of military courts in 2013 and stipulated that only wartime active duty military personnel who commit crimes under the Criminal Code of Armed Forces or Special Codes concerned shall be court-martialed. Under this context, Judgment 112 宪判 6 of 2023 has paved the way for previously court-martialed defendants who might have been wrongfully accused to petition for a retrial with the civilian court. Summary of the judgment holding. Article 181, Paragraph 5 of the MTA stipulated that when the defendant disagrees with the imprisonment sentences announced by the appellate high military court, he or she may appeal to the High Court under the reason that the judgment is in contravention of the law and the regulation. These provisions does not contradict the right to judicial remedy under Article 16 of the Constitution. 2. The petitioner may motion for a retrial with the Taiwan High Court, Kaohsiung Branch Court within the peremptory period of 30 days after the service of this judgment. 3. The rest of the requests are dismissed. Reasoning. 1. Scope of this judgment. The disputed provision only allowed defendants of military trial to appeal to the High Court when their judgment contradict laws and regulations, excluding appeals based on an error of fact. The provision thus concerns the limitation on active duty soldiers' right to judicial remedy. The MTA and the relevant laws did not provide military personnel the opportunity to appeal in situations where the court-martials finds the involved soldiers guilty, whereas the civilian court finds their civilian accomplices innocent for the same criminal incident. This also raises the question as to whether the protection of the right to judicial remedy is unconstitutionally insufficient in the current legal framework. This case also concerns the matter of supplementing JY interpretation 436. This case also concerns the matter of supplementing JY interpretation 436. 2. Relevant constitutional rights and the principle of review. The military court system holds military trial, that is court-martial, under the MTA, which is a special litigation procedure that concerns military personnel's freedom and the right to judicial remedy. Where the military court convicts the accused soldier based on primarily the same evidence which the civilian court has acquitted the soldier's civilian accomplice with a disaccord in evidence appears, and the convicted soldier shall have a way to judicial remedy. Said way has to meet the requirement of right to fair trial under the constitutional principle of due process. 3. In terms of the Part 1 of the holding, the disputed MTA provision only regulates that the defendant of military trial may appeal to the High Court, which is a civilian court, on the grounds that the judgment has contravened the law and the regulation. The provision does not stipulate for the defendants to appeal to High Court on the basis of an error of fact. This is how the judicial tier system is designed. The prosecutor general may initiate an extraordinary appeal to the Supreme Court if he considers the High Court's ruling of appeal case inappropriate. The prosecutor general may initiate an extraordinary appeal to the Supreme Court if he considers the High Court's ruling of the appealed case inappropriate. Viewing from the disputed provision's racial legend, its purpose is to realize the JY interpretation 436. The interpretation allows military trial defendants sentenced to more than an imprisonment sentence to appeal to civilian courts on the ground that the judgment has contravened the law and the regulation. The provision does not concern other grounds of appeal. Therefore, one cannot argue that the provision is unconstitutional simply because it did not stipulate on relevant appeals to High Court based on error of facts. In terms of Part 2 of the holding, objectively guilty and innocent cannot be deduced from the same facts at the same time. So, objectively guilty and innocent cannot be deduced from the same facts at the same time. If offenders of the same criminal case that shared the critical evidence were sentenced separately by civilian court and military court as one guilty and one innocent, this contradiction in nature would go against the general public's sense of justice. Ergo, for the same criminal cases, if the civilian court has found one of the offenders not guilty and the case finalized, while the military court has found the other offender guilty, the former's decision is sufficient to raise reasonable concerns over whether the fact-finding of the latter is accurate. According to the requirement of the principle of presumption of innocence and the principle of indubio pro reo under the rule of law, where contradiction in fact-finding as such arises, the person who was found guilty shall have an opportunity to motion for a retrial. Considering this kind of contradiction arises from the two-track system of civilian and military courts, the doubt in one of the court's fact-finding only appears to be more apparent, so much so that this situation should be listed as an individual ground for retrial. So, there is an individual ground for retrial that is one of the court's fact-finding appears to be more apparent, so much so that this situation should be listed as an individual ground for retrial. To prevent miscarriage of justice, to ensure soldiers' right to judicial remedy, and to meet the requirement of the right to fair trial, the limitation of retrial in Article 420, Paragraph 1, Subparagraph 6 of the Code of Criminal Procedure should not apply to this situation. Relevant laws fail to meet the requirement of due process and the subsequent right to a fair trial, for not providing legal grounds for retrial in the aforementioned situation, consequently infringing the soldier's right to judicial remedy under Article 16 of the Constitution. Under Article 1, Paragraph 2, and the proviso of Article 237, Paragraph 1, Subparagraph 2 of the current MTA, soldiers in the aforementioned situation should motion for retrial with the civilian court with jurisdiction.